And there has to be a determination, at least on remand, of what's official, a two-stage determination of what's official and what's private.
Well, if you expunge the official part from the indictment, how do you, I mean, that's like a one-legged stool, right? I mean, giving somebody money isn't bribery unless you get something in exchange. And if what you get in exchange is to become the ambassador to a particular country, that is official, the appointment. It's within the president's prerogatives. The unofficial part is I'm going to get $1 million for it. So if you say you have to expunge the official part, how does that go forward?
This particular indictment, where we say virtually all the overt conduct is official, we don't believe it would be able to go forward. I mean, there could be a case where it would, but if you look at even the government's brief in this case divides up the indictment into things that, other than the electors' allegations, don't really they haven't disputed that they are official acts, but what they do is say, well, we tie it all together by characterizing it as done, and these are the allegations that the court just referred to, by an improper private aim or private end. Again, that's their words, and that just runs loggerheads, you know, dead set against this court's case law, saying you don't look at, when immunity determinations, the motive, improper motivation or purpose.
It's gone. Let's say this president who ordered the military to stage a coup. He's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act. If it were an official act, again, he would have to be impeached.
Well, what does that mean, depend on the circumstances? He was the president. He is the commander-in-chief. He talks to his generals all the time, and he told the generals, I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand, because the framers viewed that kind of
if
very
it's an
low
official
risk.
act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific, context-specific determination.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad, and that's why the framers have a whole series of structural checks that have successfully, for the last 234 years, prevented that very kind of extreme hypothetical.
I'll be totally honest with you. Listening to the arguments and listening to what's going on in the Supreme Court, you just get the feeling, did the Supreme Court just think, we'll have this hearing just to totally trash another Trump lawyer? Where does he get these lawyers from? They are just hopeless. In fact, calling the Trump lawyer hopeless that's a compliment.
Apply it to the allegations here. What is plausible about the president assisting in creating a fraudulent slate of electoral candidates? Assuming you accept the facts of the complaint on their face, is that plausible that would be within his right to do?
Absolutely, Your Honor. We have the historical precedent we cite in the lower courts of President Grant sending federal troops to Louisiana and Mississippi in 1876 to make sure that the Republican electors got certified in those two cases, which delivered the election to Rutherford B. Hayes. The notion that it's completely implausible, I think, just can't be supported based on the face of this indictment, or even
knowing that the slate is fake. Knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state. He knows all those things.
The indictment itself alleges, I dispute that characterization. The indictment affixes the word label to the so-called fraudulent electors. It affixes the word fraudulent, but that's a complete mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state conventions, and this was being done as an alternative basis. But I want to
ask you,
go ahead.
Go ahead. So you concede that private acts don't get immunity?
We do.
Okay. So in the special counsel's brief on pages 46 and 47, he urges us, even if we were to decide or assume that there was some sort of immunity for official acts, that there were sufficient private acts in the indictment for the case to go back and the trial to begin immediately. And I want to know if you agree or disagree about the characterization of these acts as private. Petitioner turned to a private attorney, was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results. Private?
As alleged. I mean, we dispute the allegation, but
Of
that
course.
sounds private to me.
Sounds private. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations to support a challenge.
That
Private.
also sounds private.
3 private actors, 2 attorneys, including those mentioned above, and a political consultant helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and petitioner and a co-conspirator attorney directed that effort.
You read it quickly. I believe that's
Yeah.
private. I don't want to.
So those acts you would not dispute. Those were private, and you wouldn't raise a claim that they were official.
As characterized, what we would say, Your Honor, if I may, what we would say is official is things like meeting with the Department of Justice to deliberate about who's going to be the acting Attorney General of the United States.
Sure.
Communicating with the American public, communicating with Congress about matters of enormous
Thank you.
concern.
Thank you.
If a president sells nuclear secrets to a foreign adversary, is that immune?
That sounds like similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before.
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You'd probably have to have more details to apply the Blazing Game analysis or even the Fitzgerald analysis that we've been talking about.
So as the Supreme Court hearing gets underway, Clarence Thomas, there are some people outside the court, there is one thing which does strike me. The Trump family live in this delusional world where they think it's a non-stop reality show. They film themselves doing everything. Just want to put that out there. Most of us are looking upon what's happening in the Supreme Court as a really serious, just line in the history of the Constitution of America. But for the Trumps, it's just another piece of content, something else for them to talk about. Jamie Raskin has had something interesting to say on the whole subject.
That he committed as president, and he says that those acts that he was doing on January 6th were related to his job as president. I'm sure you reject that. But what about the larger issue of presidential immunity? Do you think there is nuance there?
The core part of the president's job under Article 2 of the Constitution is to take care that the laws are faithfully executed, including the laws relating to the presidential election and the Electoral College. So the idea that he was undertaking his constitutional responsibilities when he levied a mob to come and attack the U.S. Capitol, when he tried to get his own vice president to step outside of his constitutional role and just declare Trump president, is outrageous. So like the district court found, like the D.C. Circuit panel found, his claims are just utterly frivolous. They're just empty. It's not the president's job to try to overthrow the constitutional order. It's his job to enforce every provision of the Constitution, including one that would have him leave because he lost a presidential election by more than 7 million votes, 306 to 232 in the Electoral College. So I think it's farcical that we are where we are. The guy's appellate adjudications are now interfering with his criminal trials because he's basically bringing the whole system crashing down by his anarchical determination to violate every law and constitutional principle we've got.
And as the hearing is continuing, there are people outside who, well, perhaps they should be listening to the arguments. You can just tell they've perhaps, overdosed on folks.
Been there almost every day. Yep. We invite everybody who's in town, stop by and join our group of Trump supporters and be a part of history.
Amen.
Don't just sit back and watch this like a voyeur.
Yeah.
Trump needs our help. And without our help, I don't want to think about it.